Your Honour, my name is Green, first initial R, and I appear on behalf of the defendant, Marshall Ike. Your Honour, my client has been charged with 84 counts of breaking and entering and 1 count of stealing. I make submissions under section 590, capital A, subsection 2, subsection E of the Criminal Code, raising with this court concerns surrounding the admissibility of Ike's confessions, to which I seek a ruling that Ike's police interview is inadmissible, or in the alternative, I seek its discretionary exclusion. Your Honour, it is noted that at the time of the police interview, my client was aged 14 years. This would bring him within the definition of a child pursuant to Section 5 of the Juvenile Justice Act. Your Honour, it may be assumed that Ike's age, that being a juvenile, was reasonably obvious to the interviewing officer, and furthermore, it is important to note that the defendant is of Torres Strait Islander descent. Your Honour, I turn this court's attention to the safeguards contained in sections 414 through to 419 of the PPRA, with particular reference to the additional special requirements applicable here under section 420 for the questioning of Aboriginal and Torres Strait Islander persons, and section 421, questioning children. Your Honour, section 421 applies if a police officer wants to question a relevant person and reasonably suspects that that person is a child. The provision denotes that the officer must not question the child unless, before questioning starts, the police officer has, if practicable, allowed the child to speak to a support person chosen by the child in circumstances in which the conversation will not be overheard, and a support person is present while the child is being questioned. Your Honour, a support person was provided. A social worker by the name of Mary was provided by the Mornington Police Station. Mary was arranged to meet with Ike prior to the police interview and was present throughout the duration of that interview. Conversation even took place between Mary and Ike prior to the police interview, and it is my understanding no one else was privy to that conversation. However, Your Honour, Mary was introduced to Ike prior to the commencement of the police interview. They were not acquainted with one another, they were unfamiliar with one another, and so this would indicate a breach of section 421, subsection 2, subsection A of the PPRA, which denotes that the support person must be chosen by the child. Furthermore, Your Honour, Mary was not a parent or a guardian. She was not a lawyer, nor an adult relative or friend, per the definition of support person with respect to the child provision under Schedule 6 of the PPRA. And I've been further guided to assume that Mary was not in fact a person acting for the child who is employed by an agency whose primary purpose is to provide legal assistance. Subsection B, subsection 3 of the support person definition. Your Honour, I am unsatisfied Mary was an appropriate support person. I now turn the court's attention to section 29, subsection 1 of the Juvenile Justice Act. Your Honour, this provision provides, in a proceeding for an indictable offence such as stealing or breaking and entering, a court must not admit into evidence against the defendant a statement made or given to the police officer by the defendant on a child, unless the court is satisfied a support person was present with the child at the time and place the statement was given or made. Your Honour, I am unsatisfied Mary was an appropriate support person as defined, and therefore her presence failed to satisfy section 29, subsection 1 of the Juvenile Justice Act. It is my first submission, Your Honour, that the police interview tendered to this court is inadmissible. Your Honour, I'd now like to turn the court's attention to my second submission, seeking the discretionary exclusion of the police interview. Your Honour, in the 2007 case of M versus the Queen, Justices Gamau and Hain provided that evidence of a statement made during questioning by police is taken to have been obtained improperly if the investigating officer did not caution the person. This is specified in section 139 of the Commonwealth Evidence Act. Section 138 of the Commonwealth Evidence Act states that if any evidence is obtained improperly, the court may exercise its discretion to exclude such evidence. Your Honour, at no point was my client cautioned of his right to silence. Section 138 applies, and a balancing exercise to determine whether the desirability of admitting this evidence outweighs the undesirability of admitting evidence that is obtained in such a way. This is the lead discretion. Your Honour, while the prosecution may argue that the admissions are of high probative value, I put it to this court that significant contravention of procedural policy, not just limited to the failure to caution, was demonstrated. Not only was my client not cautioned, not once was I even asked if he was aware of what was proceeding before him. The interview had significant potential impact on my client's future state of liberty. This is a direct violation of the QPS Operation Procedure Manual, paragraph 6.3.2. Secondly, if the court so indulges me, Your Honour, gratuitous concurrence with respect to Aboriginal and Torres Strait Islander persons is the assent to every proposition put before them, often occurring when confronted with persons of authority. IKE's admissions were obtained through a series of leading questions met with grunts, nods and monosyllabic answers. It is my view, Your Honour, the interviewing officer should not have accepted IKE's monosyllabic responses, as this is likely to be a display of gratuitous concurrence. In closing, Your Honour, I put it to this court that the conduct of this state affected my client's right to silence. Pursuant to the lead discretion, I argue IKE's confessions should not be admitted as the desirability of admitting the evidence fails to outweigh the undesirability of admitting evidence obtained in such a way. Your Honour, it is my submissions that the charges arising out of the alleged admissions in the record of interview be dismissed, or in the alternative, I seek their discretionary exclusion, as Your Honour pleases.